Good morning, ladies and gentlemen. My paper is titled Emerging Issues in Arbitration Law and Practice in Kenya. How many of you have got experience in arbitration as a party, as an advocate, or as an arbitrator? Hands up, please. Wonderful, wonderful. I can see many people here have interacted with the arbitration. So the things I'm going to talk about are not strange. But even for those who have not interacted with arbitration, I keep telling people arbitration is actually the easiest law regime in Kenya, because it is one act of parliament and it's not even 30 pages. As lawyers, you have interacted with the Companies Act, which you need a pickup to carry around, or the old Cap 300 Registered Land Act, and 101 other acts of parliament. Arbitration in Kenya is governed primarily by the Arbitration Act of Kenya, 1995, as amended. It's just one act of parliament. So nothing I'm going to talk about is beyond comprehension or even difficult at all. That first bullet point there was meant to be a little closer to the left, but it defined all my orders for directions as I was toying around with my computer. So that's why it's hanging somewhere. Now that's the background of international arbitration, or the background of arbitration internationally. International arbitration law, as we know it today, arose or developed after the Second World War. The UN itself was founded in 1945, actually the year the Second World War ended. Now the New York Convention on the Recognition and Enforcement of Foreign Arbitration Awards, that's a treaty on arbitration awards, it's of 1958. Then there is the UNCITRO arbitration rules of 1976 and of 2010. And then there is the model arbitration law of 1985, amended in 2006. The other great development is the IBA guidelines on conflict of interest in international arbitration. That one is very important, because even though it is not mandatory, and it's also just a guideline, it has become a benchmark all over the world. It was developed by IBA, but it has become a benchmark all over the world in terms of conflict of interest. Because even though our act and other acts have provisions for declaration of circumstances which could lead to justifiable doubts as to the arbitrator's impartiality and independence, the act does not go beyond that. But that regime goes very deep into what should be disclosed, what should not be disclosed, under what circumstances must the arbitrator recuse himself, under what circumstances should he or she ideally proceed with the arbitration. There is another regime at the bottom there, it's not very clear. It's IBA guidelines on party representation in arbitration. It's also from the IBA. It's not very popular, especially in Kenya, because of a requirement there that party representatives have a duty not to knowingly deceive the tribunal. That's why that particular provision is not very popular. Now, the background in Kenya, there are two very old legislations. I'll not go into those. One of the recent legislations in terms of arbitration law is Cap 99, which is the Arbitration Act of 1968, and that was repealed by the Arbitration Act of 1995. Then there was the New York Convention, to which Kenya acceded in 1989. The Chartered Institute of Arbitrators was established in 1984. I've listed it there. It's not a statutory body, it's a professional body, but it takes a leading role in the promotion of arbitration in this country. Last but not least is the Nairobi Center for International Arbitration. The Act was established in 2013, and the center is up and running. It has published its own rules for arbitration and mediation, it is a game changer in terms of arbitration practice in Kenya because of reasons I will mention shortly. Now, drivers of change. The drivers of change are listed there. The drivers are basically that the arbitration practitioners, parties, and stakeholders are dissatisfied with a number of things. I've listed them there, and then I'll discuss them one by one. One of the things which has caused dissatisfaction is the Arbitration Act, our Arbitration Act of 1995 as amended in 2010. Consider Section 6 of the Arbitration Act. It says, a court before which proceedings are brought in a matter which is the subject of an arbitration agreement shall, if a party so applies, not later than the time when that party enters appearance. So, that is a hurdle. I have underlined it there. Not later than when a party enters appearance. Now, entering appearance is really of no legal consequence and should not be a barrier or a determinant to anything at all in court proceedings or in arbitration, because it's basically an advocate or a representative coming to say, I will be appearing for so and so. That is all. There is nothing else to it. In fact, in arbitration, we don't usually require notices of appointment. Now, why should the mere entrance of appearance be determining whether that party will proceed with arbitration or not? It's a most weird provision, and I have interrogated it in detail elsewhere. Now, the model arbitration law from which our law is copied has a different threshold. It says, a court before which an action is brought in a matter which is the subject of an arbitration agreement shall, if a party so requests, not later than when submitting his first statement on the substance of the dispute. That is more or less the international practice, because the model law has been copied by many countries all over the world. Even the ones which have not copied basically take the position that if the respondent files a response or a party takes a step in the court proceedings, then it has waived its right to arbitration. So you can see that our law is not really up to standard, because it penalizes a party on the basis of merely entering appearance. Now, the Constitution of Kenya 2010, Article 59 2C, I'm sure you are very familiar with it. The Constitution supports arbitration and other ADR procedures in that section and elsewhere. However, the same Constitution grants various rights, some of which grant parties rights for the cases to be heard by courts, in spite of one, an arbitration agreement, and two, the prohibition of court interference in arbitration according to Section 10 of our Arbitration Act. And there is a good example of a case known as Biatosha versus Kenya Breweries and others. Biatosha is a beer distribution company in Nairobi. Its contract was terminated by Kenya breweries for some reason or other. We don't need to get into the merits, but it's primarily a beer distribution contract. Kenya Breweries wants to go to arbitration, but Biatosha argues that the matter is not arbitrable because it hinges on Biatosha's right of employment and right of work and right to earn money as guaranteed in the Kenyan Constitution. The High Court decision by the late, not later, by the late Justice, the High Court decision by the late Justice Oguto was appealed against in the Court of Appeal, and it is still pending there. All the same, a secondary issue has ended up in the Supreme Court, and of course that must be determined first before the Court of Appeal can render its decision. And you never know, even the Court of Appeal's decision on merits might still end up in the Supreme Court. So that is an example of a situation where the Constitution of Kenya gives, with one hand, making arbitration a constitutional right, if you like, but on the other hand, other provisions of the Constitution are suggesting, or some parties have suggested that they can avoid arbitration, saying that a matter which touches on their constitutional rights is not arbitrable. Now, ad hoc arbitration. This is a system where once the arbitrator is appointed, he is left to his devices. It has its advantages and disadvantages. But here, for the purpose of this discussion, I'll just highlight some of the criticisms against ad hoc arbitration. And this is ad hoc arbitration compared to administered arbitration, where the appointing authority both appoints the arbitrator, supervises the arbitrator, and manages the arbitration process. That is administered arbitration. The first problem, or the first criticism, a major one against ad hoc arbitration, which is very common in Kenya, is that it creates tin gods. So such that an arbitrator has near absolute powers, and as you know, absolute power corrupts. The other criticism is delayed arbitration awards. Sometimes arbitrators delay awards because they have not been paid, or parties have not complied with various directions. But there are cases where even after the arbitrators have been paid their fees, and the parties have complied with the directions in terms of submissions and written statements and all that, the parties still don't have their award. Now, the third problem is the quality of awards. Because there is no oversight on the arbitrator, the quality of awards have been criticized. The other point is that arbitrators determine their own fees. If all arbitrators are honest, that should not be a problem, because if it's on an hourly basis, they should just produce a schedule showing how many hours they have logged in for various activities, and that can be interrogated by the parties. But here, I must say that not all arbitrators are transparent regarding their time schedules, and this has been a big problem where you have gone through the process, the award is now ready, and the arbitrator tells you he wants $1 million shillings or 2, and you don't think that what he has done justifies that fee. And then in an ad hoc arbitration, what remedies do you have? There is a procedure provided in our Act, and it is for you to apply to court for the determination of the arbitrator's fees, but you must, in the first instance, pay the money which the arbitrator is asking for. It's a rather awkward procedure. And then there is no independent person to hear party complaints about the process or costs. Because the arbitrator is on his own, and he's the one determining the case, parties are hesitant to complain to him directly about delays here and there, or procedural problems, or even costs. There is a procedure, of course, for the parties to remove the arbitrator, which is quite drastic, and sometimes the parties can't agree to remove him because one party usually benefits when the process is taking longer than expected, so they cannot agree to fire him. The other procedure, of course, is for one party or both parties to apply to court for the removal of the arbitrator. That works, but again, parties don't want to have that arbitrator removed and then a new one appointed and they have to start from scratch. So that remedy is also problematic. Now, complaints about appointing authorities. The main appointing authorities, that is the main arbitrator appointing authorities in Kenya are the Law Society of Kenya, Chartered Institute of Arbitrators, Kenya Branch, Architectural Association of Kenya, Institute of Engineers of Kenya, Institute of Quantity Surveyors of Kenya, Nairobi Center for International Arbitration, which also carries out administered arbitration. And then the High Court is an appointing authority because when there is a default in the appointment mechanism, the High Court kicks in and appoints an arbitrator under the Arbitration Act. Then the Chief Justice is also an appointing authority, either at a contract because parties can agree that he is the appointing authority, or he is an appointing authority under various statutes. Now, what are the complaints about or against appointing authorities? One is delays in appointment. You apply to an appointing authority saying you have a dispute and attaching all the relevant papers, attaching the payment. Then you wait 2 weeks, a month, 2 months, 3 months. There have been cases where the appointing authorities have not made an appointment 9 months after the request was made. And with respect to that particular appointment authority, there was no requirement for a fee to be paid. There was nothing. You just need, for that particular appointing authority, you just need to apply for the appointment of an arbitrator. 9 months down the line, with no good justification. The other complaint is that there are cartels which interfere with appointments and ensure that appointments are restricted to a small pool of arbitrators. Then lack of transparency. What is the appointment criteria? Members of the public would like to know what is the appointment criteria. The other thing they would like to know upfront is who are in your pool of arbitrators. If I am a contracting party and I want to nominate or to name the Law Society or Chartered Institute of Arbitrators or Nairobi Center for International Arbitration, whoever, I would like to be able to know in advance who are in the pool, the organization's pool of arbitrators. Yeah? Because it will either give me confidence or otherwise, in which case I'll choose another appointing authority in my contract. Then there is the complaint about unjustifiable repeat appointments. The government particularly has complained that some appointing authorities are prone to make repeat appointments to certain arbitrators for whatever reason. Then there is a complaint that our appointing authorities have been appointing unsuitable persons for the task. That is, people who have the expertise, experience, or even time to devote to the arbitration proceedings. Then the appointing authorities, many of which are professional bodies, freestanding professional bodies, are not taking disciplinary action against their own members when there are complaints arising from arbitration. Those are very serious complaints, but there are also complaints about the parties and their lawyers. I've grouped them together because a lawyer effectively stands in for the party. So at first I had drawn a distinction, complaints against parties and then complaints about lawyers. And then I merged them together because sometimes the line is very faint. Now, One complaint is that they resist arbitration needlessly. Number two, procedural delays. Then there is delay or failure in paying the arbitrator's fees. Then challenging the arbitrator's awards needlessly. And then unfamiliarity with arbitration law and procedure among some lawyers, not all of them. Now, the courts. There have also been some complaints about the courts that some judges are said to be doing the following for no good cause. They are not apparently enforcing arbitration agreements, so they are ignoring the existence of arbitration agreements. Then they are not enforcing arbitration awards or looking for very flimsy grounds to set aside arbitration awards. The third complaint about judges or courts is that some of them treat applications to set aside arbitration awards as if they were appeals of the arbitration awards. The other complaint is that some apparently entertain hopelessly flawed applications which should ideally be dismissed summarily, and I should add there the costs. Then it has been said that some judges seem to be unfamiliar with the arbitration law. This is something which requires interrogation, because everybody who loses a case in arbitration or who loses a case in court in Kenya starts throwing mud at the person who made the decision. Is it true really that some of our judges are really unfamiliar with the arbitration law? As I said, it's one act of parliament. How many acts of parliament does a judge normally deal with in a year? And here we are talking of one act of parliament, and applications to court are not normally made under all the sections. It's usually three. One, removal of the arbitrator for whatever grounds. Two, arbitrations to set aside the arbitration award. Three, applications to enforce the arbitration award, which is the backside of the point I said earlier. And then, of course, there is enforcement of the arbitration award by referring dispute to arbitration, and also situations where parties have complained about the arbitrator's conflict of interest. So we are talking of applications arising from not more than 5 small sections of the Arbitration Act. So when we say that judges need training in arbitration, we need to be very careful not to insult them. One of us among here, Mr. Mwai, apparently has written quite a bit about the allegations that judges are unfamiliar with arbitration law. Maybe he will contribute to the discussion during the plenary. That's Madege Mwai. He's a quantity surveyor and an advocate. Now, solutions to all those challenges which I have listed exist, but they vary very widely depending on who you are talking to. And so I have restrained myself from listing solutions to those problems, because some of the solutions are quite obvious. Instead, I have, because this is an LSK function, decided to talk about the emerging opportunities. Because of those challenges, what are the emerging opportunities for the Law Society of Kenya? And here I've not numbered my bullet points, so I'll give you an exercise. It's a simple exercise. Please count with me with your fingers the way your mother or your father taught you. So when I say one, you show me one the way your father or your mother taught you. Actually, it's a very customary thing because different people count differently and for different reasons. So we'll start with number one. My mother taught me number one is this. Yeah, we seem to be in agreement on that one. The LSK could develop an effective mechanism for disciplining errant members, whether the complaints are about their involvement in arbitration or the practice of law. You have advocates in Kenya have two disciplinary mechanisms. The one is the one at the professional body and the statutory one. There is debate as to whether those mechanisms work. Incidentally, my primary profession, which is valuation surveying, I'm a property valuer, we also have two levels. There is a disciplinary mechanism at the Institution of Surveyors of Kenya, the professional body, and there is another one at the Valuers Registration Board, which is a statutory body. And that kind of format exists in other professions, architecture, quantity surveying, and many others. Does it work? Ladies and gentlemen, my humble submission is that they do not work either singly or in combination. They don't work. You are lawyers, you know the complaints against lawyers. You know the complaints against the two statutory, the professional body disciplinary mechanism and the statutory body mechanism. The AG last year or the year before gazetted a list of advocates who had been removed from the role of advocates. I was excited when I saw that because I thought we were starting to move somewhere. But I looked at the list and I saw in that list an advocate who had been barred from practicing law about 10 years ago. So that told me that list was of advocates who had been barred from practicing law for maybe 20 years, and they were only 20. What I have said about LSK is the story in my primary profession, in the medical profession, in the project surveying profession, is the same across the board. The existing disciplinary mechanisms among professionals are not working. We need to find a solution. Now, strengthening partnerships between LSK and Chartered Institute arbitrators for training. There is already either a partnership or an MOU or just plain understanding, and it seems to be working well, but I suggest that it should be strengthened. That is number 2. That's my number 2. Ah, wonderful. I think we are still counting this. Ah, yeah, number 2. Now, drama starts in number 3. Partnership with courts. I'm suggesting that Law Society of Kenya should form partnerships with courts in order to promote arbitration. And there is an example, I will not go into details now, but there is a regime in the United Kingdom called Professional Arbitration Under Court Terms Pact. In that regime, the lawyers, the professional bodies of lawyers in the UK, and the professional body of chartered surveyors or valuers and quantity surveyors, those two have come together and agreed with the courts on a way of handling arbitrations from court or which would go to court, but handling them privately. It has worked well for a couple of years, and I don't see why we cannot try that here on the same format or a different format. Now, that is number 3. This is the way I was taught. 3? Ah, show us. Yeah, that's where the drama starts. From there we count differently. ISK needs to walk the talk by arbitrating disputes within the LSK as per the rules. The rules are already there, they provide for arbitration, but somehow whenever there is a dispute between an LSK member and an LSK organ, it goes to court. So the applicant, I think, is at fault because the rules require that the complainant goes to arbitration. But there is a second arm to it. As far as I know, LSK has never gone to court and said this dispute should not be in court because there are existing statutory rules which require that such disputes be referred to arbitration. So both parties are at fault. The ones taking LSK to court, and in my view, LSK is at fault for not citing that rule which requires that such disputes be arbitrated. I have looked at the rule and it's not very efficient, but again, that is something which can be amended to make it more friendly. So that is number 4. Number 4. Number 5 is LSK could also develop arbitration rules. The Chartered Institute of Arbitrators has arbitration rules, and its members generally use those rules in their arbitrations. But there are many arbitrators who are members of LSK and not members of Chartered Institute of Arbitrators. And I think LSK should provide rules, modern rules, practical rules, simple rules for use by such arbitrators, and if they are good enough, other arbitrators. Because parties will look at CIF rules, they will look at LSK rules and other rules and agree these are the rules which we find suitable for us for this dispute. Now, that is number 5, the one I've just... This is the way my mother showed me, number 5. Yes, please. Yeah. There are people who count number 5 that way. It's open. Mine is closed. Okay. Number 6. Administering arbitrations. As I have said, Nairobi Center for International Arbitrations is already administering arbitration. It is providing logistics to the arbitration process and supervising the arbitrator. There is no reason why LSK could not also start administering arbitrations at a fee, of course, which LSK would be happy about. That is number 6. This is my number 6. Oh, okay. Now, or number 6 like this, for emphasis. With the right hand or with the left hand? Right hand, number 6, or number 6, or number 8. Okay. That is number 6. Now we go to the other one. Preparing a panel of arbitrators. As a member of the public, when considering whether to list the Law Society of Kenya as the appointing authority of the arbitrator, I would like to know who are on the LSK list of arbitrators and what are their qualifications, not just names. Not just names there and that they are members of the LSK. I want to know if they qualified yesterday or 20 years ago or 30. I want to know if what qualifications they have in arbitration, not in law. Because those are two completely different disciplines. Somebody could be a very experienced litigator, a very experienced lawyer, judge, but not quite trained or experienced in arbitration. Those are things I would like to know. As of now, they are simply not there. LSK and the other appointing authorities do not, as far as I know, list the panel of arbitrators and their qualifications on their websites. I'm sure if you ask, you'll be told. But that information should be available freely on the website. On the websites. I should not have to pay for it. I should not have to ask for it. I should just click a button and get to know who are eligible for appointment as arbitrators within the Law Society of Kenya. One organization in Kenya, the Institute of Quantity Surveyors of Kenya, publishes every year its list of arbitrators, but it does not show their CVs or their profiles or other details. That is number 7. Number 7, please. Oh, please raise that up because, yeah, that's his number 7, like this. Okay. Now, the other point is to do with the advocate's remuneration order. I've framed this as a question. Is that order suitable for the determination of legal fees, that is representation fees, or the arbitrator's fees? The Chartered Institute of Arbitrators has its regime of fees based on time. What are the basis of arbitrators' fees under the Law Society regime? And is it good? Is it workable? That is number 8. Number 8, please. Number 8. Good. We are now going to number 9, which is a question. The Law Society Arbitration Center. It's a question because LSK has discussed that matter for a long time. I'm not a member of Law Society, so I can speak without fear or favor. And I would like to suggest to you that the Law Society Arbitration Center is long overdue. There may be logistics you need to work out among yourselves or between yourselves about various things, but the idea itself, the vision of an LSK arbitration center is good and must be pursued. That is number 9. Let me see your number 9, please. Number 9. Ah, good. Those are 9, but I will add a 10th one for good measure. And it's that we need, much as we have been complaining about arbitration and arbitrators, we need to come up with ways of recognizing arbitrators who have excelled, or prizes of recognizing people who may not be arbitrators but who have made great contributions to arbitration law and practice in Kenya. That is point number 10. Please show me your number 10. Your 10. Ah, wonderful, wonderful. Well done. Asanteni sana, see you in arbitration. I like talking about arbitration. That is my number. It is showing there. You may call me on that number or send a text message. And my email is also shown there. It's not very clear, but if you Google my name, you will get my email address. I have written 2 books. One is on arbitration, contemporary issues in arbitration. It's a collection of close to 20 arbitration conference presentations I have made over the years. And I also write poetry. Obama Amama is my collection of poetry collection. Both books are on display and on sale somewhere somewhere out there. This one goes for 2,500 shillings. That is the arbitration book. This one for 1,000, the poetry book. So the total is 3,500. But if you buy both, then you will get a discount of 500 shillings. So you take it for 3,000. Thank you very much for listening to me and for counting and for showing me how your mother taught you how to count. Thank you.